So again, coming on to European Union law. So because we are part of the EU and we are still part of the EU, any European Union law that's agreed and passed is enforceable in the UK as part of our party to the EU. It's got to be applied directly by any relevant countries within the EU. So whether the country agrees with it or not, is regardless, it is applied. And that's why when there's obviously these meetings in Brussels and there's discussions about passing legislation and things rolling out, that's why the country's presence at those meetings and the country's party to those meetings is really vital, because if for whatever reason it can't be passed within that country, then it needs to be brought to the table and discussed. So again, regulations apply to all member states. And the directives are usually binding for all member states. There are sometimes time limits on those directives. So the directive could be effective for a 3-year period. And sometimes, I can't think of an example, but sometimes there's good reason for that if something is very current and it needs to be caught within a particular net. So, relating to Brexit, we as a country have actually implemented a number of our own legislation, so UK law, UK statute, in relation to EU law. So it would be very difficult to unravel all of those statutes and regulations that we're now all working to, and people are contracted to, people are, it's all as part of our daily work activities, would make it very difficult for EU legislation to come out of that. It would make some of that ineffective, and actually could be quite detrimental to some of the ways we work. There's a working time directive. Have you heard of that? So the 48 hours within a 17-week working period, etc. That is EU legislation. Now, from the top of my head and from knowing about the working arrangements that are in place, I can't see that if that was to come out, that would be too detrimental to anything. So I think there would probably be other regulations that the country would want to implement to still govern and make sure people aren't working too much, and that they're requested, they're asked basically permission if they would like to work more than a certain amount. It is a good protection for employees, but generally it can be quite a tough one to work out for people that do different regular hours, or don't have regular hours, do different hours and things like that. So, but there are others as well. So, types of employment law. These areas I've listed aren't exhaustive. There's loads more, but I just thought I'd name a few examples. So we've got individual employment law. So that looks at employment protection, things like equality, providing information to employees, making sure employees are well informed and made aware of their terms and things like that, and company guidance and company rules. It basically, individual employment law is basically all about employment rights, really, generally, and equality. There's health and safety. So within employment law, there is a key guidance around health and safety, and making sure that we are clear and thorough on working conditions and things like, pregnant workers guidelines and guidance, and very prescriptive about procedures that we might follow for pregnant workers, and working time, for example, so that we're not asking too much of our staff or too little. So the whole thing about 0-hours contracts and things like that will come under things like health and safety, but potentially or also individual law as well. And then collective. So in things like industrial action and individual freedom to representation. So these are trade unions and the right to be represented. So when we were going through capability and disciplinary procedure, when we invite people to a formal meeting, a formal company meeting that's as part of one of those procedures, we have to allow somebody the right to be represented, and that can be a company representation or trade union. It can't be mum or dad or cousin. It's got to be a company representative. The notion is that person would be involved and understand the company's procedures as well as the case that they are there to represent for the individual. There's certain things that they can't do, like answer questions for the employee, but it can certainly help in terms of having a witness if the employee is feeling disorientated or particularly under strain or stress from the case.